Here's a company case to think about with regard to mandatory arbitration. Factree manufactures artificial trees and flowers. There are about 100 workers who do the routine assembly work for pay ranging from $8 an hour to $15 an hour. They work in 2 shifts. There are about a dozen supervisors who oversee their work. In the past few years, there have been 5 employment lawsuits. 3 concern sexual harassment and 2 concern discrimination and promotion. All 5 settled before trial. For 3 of the suits, the company's attorney's fees were over $50,000 per suit. For one of the claims, the company paid $250,000 in damages to the employee. The company is considering mandatory arbitration dispute resolution for all employee disputes. What are the benefits for each side? Quite often, companies prefer mandatory arbitration because it leads to quicker decisions. Managers spend less time in discovery and trial preparation. Employees may have less ability to sustain vexatious litigation, though they may be able to file such claims more easily. Mandatory arbitration also means reduced attorney fees and reduced discovery. This means that unhappy employees will be allowed to see very few company documents concerning internal investigations of supervisors, other related claims of harassment or discrimination, employment statistics concerning gender, race, age, etc., and intra-company memoranda. Mandatory arbitration also means no class actions. The stakes may rise dramatically in a class action because the defendant faces much greater exposure. This in turn may give the plaintiff class greater bargaining leverage. Sometimes employees prefer mandatory arbitration because it reduces the cost of bringing claims. In a lawsuit, the plaintiff must first convince an attorney to accept the case on a contingent fee basis or else pay a large hourly rate. With mandatory arbitration, the employee can either perform the work herself or hire a lawyer whose hours will be greatly reduced. Most employees also like quicker decisions. A lawsuit may drag on for years, including discovery, trial, and appeal. Before the decision is final, the employee may abandon the case and his or her job. With mandatory arbitration, management will have less opportunity to club an employee into settlement by dragging out the lawsuit. Employees also like the idea of amicable settlement. Mandatory arbitration may increase the chance of an informal, amicable decision. The parties may stop thinking in terms of win-lose and strive for a rational compromise. Most employees, however, do not like having less bargaining power. The inability to bring class actions, engage in pre-trial discovery, or obtain orders enforceable by a court decreases their ability to change the employment relationship. Federal cases involve claims that are based on the U.S. Constitution, a federal statute, or a federal treaty. Diversity cases are when the plaintiff and the defendant are from different states and the amount in dispute is greater than $50,000. A litigation begins when someone makes a complaint and submits a statement listing the allegations. The allegations are then served to the accused person with a summons. The person who is served then responds to those allegations and can make a counterclaim and initiate a second suit against the person who began the litigation process. A response to this is then given to the counterclaim. There are a few possible variations on pleadings. Counterclaim. If the accused party thinks the accusing party has contributed to the problem or has wronged them, they may file a second suit in reverse of the first. Class actions. If the wrong in question has affected a large number of persons, the suit may become a class action suit with the plaintiff representing an entire class of plaintiffs. In 2005, Congress passed a statute to force large multi-state class actions out of the courts into federal. Judgment on the pleadings. Either party can ask the court for a judgment based on the initial complaint and answer, but few cases are dismissed at this point. Discovery in civil litigation is rarely the subject matter for legal dramas on TV or in the movies, so the discussion of discovery may be unfamiliar to you. The best way to bring out the truth is for the two contesting sides to present the strongest case possible to a neutral fact finder. The purpose of discovery is to enable the parties to understand their opponent's case as clearly as possible in order to encourage settlement, by allowing objective appraisal of the strengths and weaknesses of each side, and to allow a trial to uncover all relevant facts with the minimum of surprises.